Chapter 15, the judiciary, in your last chapter of the course. So congratulations for making it, just one to go. Here we go. So here is the Supreme Court building of the Supreme Court of the United States of America. I have stood right here. Had my picture taken. I cannot find that picture, otherwise I would have put it in. But pretty cool building, massive, as you can imagine. All right, here we go. So your text starts out with the case of Jason Pepper. He was a meth addict, got busted, arrested in 2004, and then a sympathetic judge gives him a lenient lenient sentence, a fraction of the time that he could have received. And then in 2009, a federal appeals court ruled that a sentence was too lenient and under federal law ordered him back to prison. In the meantime, this arrest and conviction woke him up, so to speak. He turned his life around, went to college, graduated, got married, and had just become, in a sense, what you would hope somebody would become, particularly after his earlier life. Once he gets sent back to prison, he appeals his case to the Supreme Court. And the Supreme Court ruled that the appeals court had erred on the sentencing guidelines and saw them as mandatory, not advisory. And so it did not allow them to consider the kind of exemplary change in lifestyle to determine what was appropriate punishment. And so they reversed it. And your text uses that case, and there's Jason Pepper himself right there. The text uses that case to really ask the question: what is the appropriate scope of federal power in relation to the courts? So federal courts are actually, and especially the Supreme Court, because the ultimate say comes there, they are frequently involved in policy making, particularly on such issues as abortion, capital punishment, assisted suicide, alternative lifestyle choices. That's where it has gone. It has gone into the Supreme Court to make those decisions. Not that it necessarily should go that way. You would think the legislature would be able to make those decisions, but sometimes they have not, or sometimes the decisions they have made, the court believes have erred. So critics of this idea that the court should be active, and that's why I say it doesn't necessarily have to go that way. Doesn't necessarily have to go where the court is making these decisions. So critics of this active judiciary argue that judges should not be active in determining public policy, and it should be left to elected officials. We are, after all, a democracy, and in a democracy, majorities are entitled to rule, to say what the law is, simply because they are a majority. That's what a democracy is. Advocates for a more aggressive role for the courts argue that the court has met pressing needs, especially the needs of political or economically powerless, left unmet by the normal policy process. You take, for instance, a look at African Americans, gay rights. The first changes really came from the courts, and that's what the advocates are saying. And there's some truth to both sides. The nature of judicial system in the United States. It is an adversarial system. What we mean by that, there are opponents. The idea, the theory is that the truth will come out, justice will emerge in this struggle from opposing points of view. If it's like when you were a kid and you got your one of your siblings came and complained to your parents about you, told them a story. Your parents call you over and said, "What did you do?" And then you tell your side of the story, and all of a sudden it's not quite the picture that your sibling painted. That's really kind of the same idea. It's an adversarial system, and the truth will come out if it's approached from two different perspectives. Again, the theory doesn't mean it always works, but that is the theory. So criminal laws, what are criminal laws? Those are laws that may be harmful to an individual or society as a whole, And so criminal law regulates conduct and sets out duties owed to society. If the act is committed, it is of such a nature that it warrants punishment. Those are kind of criminal laws. So we got this adversarial system, and within that adversarial system, we have a number of types of laws. One being criminal, another being civil laws. Civil laws touch the legal rights of individuals towards each other. So you're looking at duties owed from contracts or property rights, divorce, marriage law, business law, etc. These would all be parts of civil law. Now, in both criminal law and civil law, it consists really of two things: statutes, which are legislative acts, those are laws, and common law. Common law is the accumulation of judicial decisions about legal issues. So you know that the legislature makes the law and the judicial branch interprets the law. When they interpret the law, in that sense, they are making law. They're saying what the law means. All those decisions become part of the common law. You can't understand the written law without understanding how it's been interpreted, or in other words, the common law. In the U.S., there is not one court system, but there are two. So over here, we have the state side. So in the state side, there is a trial court. Now, I don't like this diagram from the perspective the U.S. District Court. So this is the federal side. This is the national government. This U.S. District Court should be, let me pause this for a second. So this U.S. District Court should really be right down here. Same level as this district court. That's where it should be. So the district court is at the same level as the trial court. They're both trial courts. The U.S. District Court is just the trial court for the federal or national government. Okay? So above the state trial court is you have an intermediate appellate court. And again, this U.S. Court of Appeals is at the same level as this intermediate appellate court. It is just on the federal side. Above the intermediate appellate court in the state is the state Supreme Court. You can't argue that the U.S. Court of Appeals is below the Supreme Court. It's just in a different line. Okay? And in that sense, there is no intermediate appellate court in the federal sense. So in one sense, it makes sense that it's right here. And then ultimately above everybody is the U.S. Supreme Court. It has the right to decide cases in both, but it doesn't decide most cases on the state side. They've got to involve a federal question. So the vast majority of cases really are tried on the state side, and they're criminal and they're civil, family, and that's where they begin and end. Most of them begin and end right here. Very few of them even get to the state Supreme Court, and far fewer get to the U.S. Supreme Court. And most of them just don't have a grounds to even get there, which hopefully you'll understand that in a few minutes as we go through. So the Constitution, the Founding Fathers realized we just can't have the courts deciding everything. And we don't want them to. We want there to be actual cases and controversies. We want somebody to have something at stake if they lose. That way, in this adversarial system, they're going to put up their best arguments. But if there's nothing at stake, there's no reason to put up your best arguments. So the Constitution restricts federal judges to deciding cases or controversies where there are actual disputes. They do not decide hypothetical situations. Not even the national government can go to the Supreme Court and say, hey, we need an advisory opinion about what you guys would do on this issue. The court just won't give them. So within the court system, the individuals involved in the case are known as litigants. The plaintiff is the individual or business or entity that brings some charge against the defendant. And this is the party being sued or charged with a crime. That is the defendant. All right. In order to sue, you need something that is called standing. So not everyone can challenge a law in court. You've got to have standing. So the person who's challenging the law, they would in this case bring the charges or bring the suit. They're the plaintiff. So the plaintiff has to have standing to sue, which is usually, I shouldn't say usually, which is always determined by whether or not they have sustained or are in imminent danger of sustaining direct and substantial injury from another party. So if you haven't sustained or you're not about to be to have this immediate harm, you just don't have standing to sue. There's got to be, in the words of the previous slide and in the words of the Constitution, there has to be an actual controversy. Being a taxpayer and having your, quote, tax dollars wasted does not give an individual standing to sue. This is wise policy because if it was, there would be endless cases that people would bring before the court saying, look, the government is wasting my tax dollars on this, or that, or the other thing. That is not enough. Your recourse, if you think your tax dollars are being wasted, is to vote somebody else in that will do something about it. So taxpayer, no standing to sue. All right, class action lawsuits. What is a class action lawsuit? Suppose you've got a situation where there are a lot of people who are similarly situated as to you. Does everybody need to bring a lawsuit? So let's say that your company is, the way they've calculated your pay, they've routinely underpaid people. Does that mean, and you go to them and approach them and they won't do anything about it, does that mean that if you sue them and get the higher pay, that everybody else in the company that is similarly situated has to do the same thing? Not necessarily. If it is sued under a class action lawsuit, all people that are similarly situated or in the similar circumstances will receive the same benefits. That's if it is filed as a class action lawsuit. So very interesting approach to that. All right, so as you can tell, we're just kind of going over a number of issues related to the courts. Now, interest groups in the Supreme Court. The Supreme Court realizes that interest groups help to shape public policy. And interest groups recognize the Supreme Court's ability to shape public policy. Because of that, what interest groups will do is they will seek out litigants who seem to have a particularly strong case because something wrong has happened to them, something illegal, something that shouldn't be has happened to them, and then they will bring and argue the case on behalf of those individuals. Those individuals really are the litigants, but the interest group is the one doing the work for them. So when Linda Brown, the little girl whose case ended segregation in public schools, the NAACP, they were looking for a case like hers where they could show that that segregation in public education was inherently unequal, and they found it in her case where it was just going to be very, very difficult for the court to say anything but what they wanted, and they were right. So interest groups will look for cases that will help advance the cause of their interest group and then bring those and sue on behalf of the individuals who were there. ACLU, American Civil Liberties Union, they do that all the time as well. Now, other interest groups are not the instigator of such legislation, such court cases. But oftentimes, other interest groups will file amicus curiae briefs, which basically means friend of the court. So when some cases come before the Supreme Court that touch a lot of different issues, individuals will say, okay, we need to have a say in this. And the court wants to hear from them because they want to get the best picture they can of what's going on. And so they have this, what's known as amicus curiae briefs, to allow individuals who are, in a sense, even affected by it in some way, to file a brief, which is a legal argument, suggesting to the court how they ought to rule, known as friend of the court brief. All right, the federal court system. So you've seen a little bit of this before back in a previous slide, this move up towards the Supreme Court. Here, what I want to emphasize is not this side. So we've already done the district courts and the courts of appeals. I want to emphasize this part over here. All right, so these are what are known as legislative courts. So legislative courts are courts that are for a special purpose. So you got the military, you got tax courts, you have federal claims court, you have international trade court, and there was some stuff on the other side over here that I just left out because you just need to know it. All right, so judges on these legislative courts have fixed terms. There's no protection against removal or even salary reductions, and there's no right of judicial review. All right, so these courts, known as legislative courts, are different from what we would call these courts over here, which are called constitutional courts. The Constitution said only about the judiciary that there would be one Supreme Court and other courts which Congress would from time to time ordain and establish. And Congress has done that, and some of these courts are known as legislative courts. All right, so on the federal side, coming back here, on this side right here, these are the constitutional courts. And again, I'm showing you a different diagram of what I had previously shown you up here, but which I think is just a little more accurate in some ways. So you've got here, again, you got the state side. So you have the state trial court at the federal level. It's known as the district court. Then you have appeals courts, and you see the appeals courts right here, not up here on the other. Then you have the state Supreme Court, and then, of course, you have the federal court. So on a diagram, let me get back to my drawing tool. What's that?
I'm gonna see my doctor at 10:30.
Okay, good.
All right, I love you.
I love you too. Sorry, I'm making that video I gotta make.
Okay, I know. I can
Okay,
tell.
all right.
Sorry. Okay.
Bye. Hey, what's up? You know what? I just force it. So, yeah, we shouldn't have, but you know what? We've always had to.
That's kind of my point.
Yeah. So you're talking about a particular kid?
No, I'm talking about I haven't seen anything that looks like a follow-up.
You know what? Let's bring it up next staff meeting.
I don't know.
I don't know that there's getting it.
That's why I'm.
Okay. So when a kid keeps getting OC and NOC, she needs to call that kid in. I don't know. And what I've done with her was, I said, hey, I sent her an email and said this kid was OC, X many times. It's probably time for you to get involved. And then she did. But see, I don't think, you know, that's what I would do. I'd say, I'd send her an email.
It seems to me that all the things that we are supposed to do is information which precise.
Yeah. 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 Good question. Good question. You know what? I'll bring it up to her and say, hey, we can talk about this next time. Just frustration.
Some sort of method that has to look down and staff has to
Yeah.
staff, maybe belongs to new staff through the first couple of calls.
Yeah.
Or something. I don't know, I don't know what has to suggest this.
Yeah. I know. And she doesn't know everything, how it works yet. Yeah. All right. Yeah, I'll say something to her. All right. Okay. All right. Thanks, Eric.